Good morning, ladies and gentlemen. As I've stated at the start of this trial, only 3 pieces of evidence are going to determine this outcome. What you're viewing now, this is the piece of evidence taken from the agent himself, the defendant. And there she is, ladies and gentlemen, the domestic terrorist herself. Really scary, huh? What is she doing? She's backing up her vehicle to make room for the agent? That's right. She puts her vehicle in reverse. And remember, at this point, she could have left. Often in trials, you hear the word motivation. Why did he do what he did? What motivated him? We're about to dive into the heart of this case. The why, the motivation. At this point, he is far away from the SUV. Seems to be casually filming. And now, here it is, ladies and gentlemen.
Big boy, go ahead.
Out of the car. Get out of
Big boy, go ahead.
Out of the car.
Big boy, go ahead.
Out of the car.
Get out of the car. In my opinion, this is it. The moment of motivation. The moment when the agent makes a decision. He could have stayed put. His training states he should have approached the passenger side door. But that's not what he did. Yep. He hears the words, "Get out of the car." And that appears to be the motivation to rush to the vehicle. But hold on. What was his intent? Was his intention to go to the front of the vehicle or to cross to the other side of it, possibly to join the other agents? Well, let's slow this down and see. No! You can see by the tip of his hair, he appears to be staring her down. Takes a few steps, and then he squares his body to the center of the vehicle. Hand on his holster. I'll tell you what this reminds me of. Reminds me of a cowboy. The motivation, the decision. In my opinion, that decision was made right here. And what was that decision? Let's call that decision the duel. And in my opinion, he planned to go to the center of that vehicle, draw his weapon, and have a duel. A duel with this woman. I hope she's ready. No! Once again, she backs up, but this time, it's to leave, to flee the scene. She makes a hard right turn towards an escape path. It appears the agent can see she's turning her steering wheel to escape. He's staring her down. But who knows? He has his video phone to manage, a gun to manage. Reckless, if you ask me. The filmmaking cowboy. Now let's move on to the shooting. This one is simple, ladies and gentlemen. Again, it comes down to choices. He could just get out of the way and let her go. The left side of the vehicle appears to end up near the agent. Realize they have her plates. They can call ahead to other agents or police, form a blockade, at worst show up at her door with a warrant. She could be arrested at a later time for any number of charges that she committed that day. But make no mistake, ladies and gentlemen, none of those crimes equal a death sentence. So what choice was made? Appears to me the choice was stand ground, fire, then fire again, and then fire again. The picture speaks for itself, doesn't it? The agent at the side of the SUV, firing into it. Again, another decision that, in my opinion, shouldn't have been made. It's really not more complicated than that. But in this country, we have politics, Republicans, Democrats. All of you in this courtroom have a certain bias. But in this courtroom, we have the law. And we're going to talk about agent training as it relates to this situation. I'm going to have my assistant, Mr. Johnson, read several key training points.
Instead of standing in front of a car, ICE officers are trained to use an approach formation known as the tactical L. How it works. Officers approach the vehicle at a 90-degree angle from the side rather than from the front or rear. The goal: this creates a mitigation zone where the officer can speak to the driver or intervene without being in the vehicle's path of travel if the driver attempts to flee. It also prevents crossfire situations where agents on opposite sides of the car might accidentally shoot toward each other.
Well, I think it's fair to say that training was ignored.
Standing in front of a vehicle is considered a violation of safety.
Standing in front of a vehicle is considered a violation. Continue, please.
Standing in front of a vehicle is considered a violation of safety doctrine known as officer-created jeopardy. The concept: this occurs when an officer voluntarily places themselves in a position of danger, like stepping in front of a fleeing car, and then uses that danger to justify using deadly force.
So why is this a violation? Well, in general, an agent could be putting themselves in jeopardy on purpose and then say, hey, I was in danger. That gave me the justification to kill. I put myself in jeopardy, and that is why I am killing. That's my justification. I'm in danger even though I caused it. Now, who would do that? Maybe agents who think they're cowboys. Continue, please.
Legal standing. Federal use of force experts and policies generally prohibit this tactic because the officer had the option to remain in a safe position to the side, but chose to obstruct the vehicle instead.
That sounds kind of familiar, doesn't it? Don't position yourself in front of a vehicle. It's that simple. And maybe move out of the way. And now to the shooting. For this next point, we're going to forget the fact that training says he shouldn't have been there in the first place. We're going to take a little reset here because this is decision number 2. What choices can he make now? He can step aside, get out of the way, or he can stand his ground and fire. Based on the evidence, once again, bad choice, ignore training, and I believe his decision was to stand his ground and fire. Mr. Johnson, can you read the next slide?
The policy states that agents should not fire weapons solely to disable a moving vehicle. If a vehicle is approaching an agent, the policy explicitly mandates that the agent must move out of the path of the vehicle when possible, rather than standing their ground and firing.
Now, it appears to me that the agent took a hybrid approach. The vehicle was approaching. Appears the driver was trying to move the vehicle out of the agent's path, and the agent appeared to sidestep just enough to stay out of the path of the vehicle and stand his ground to shoot. My opinion, that agent moved as little as possible. Continue, please.
The exception: deadly force is only authorized if the occupant of the vehicle is threatening the agent with a deadly weapon other than the vehicle itself. Example: the driver is pointing a gun at the agent.
Okay. Exception not valid here. Seems pretty self-explanatory to me. Based on the evidence I see here, it appears 3 shots may have been fired. And I would argue, and it is my opinion after viewing this video, the agent was out of harm's way when firing those final shots. Simple math tells me that if one bullet went through the windshield, the other 2 supposed bullets went through the driver's side door at point blank range. But I'm just speculating. Next slide, please.
The objective is not to kill the subject, but to stop the aggressive action immediately. Once the threat stops, the officer is trained to stop shooting.
The officer is trained to stop shooting. I'll tell you what I observe. Point blank range right into the driver's side window. Look at the positioning, ladies and gentlemen. Do you think the officer is still in danger? I believe there was no reason to keep shooting. As you can see, the SUV wasn't headed towards a crowd of people in any position to cause a threat of any kind. And now, I'm going to summarize this case by citing case law known as Felix versus Barnes. You see, I know what the defense is going to do, so I'm going to do it for them. They're going to show a lot of this. They're going to try to convince you that this agent got hit, even though it appears he may not have. They're going to say he was in danger, therefore he was justified. Mr. Johnson, please read the next slide.
The incident: Officer Roberto Felix Jr. stopped Ashti and Barnes for a toll violation in Texas. The escalation: Barnes tried to drive away. Instead of letting him go or moving aside, Officer Felix jumped onto the door sill of the moving car. The shooting: While clinging to the moving car, Felix claimed he feared for his life because he was now hanging off a moving vehicle and shot Barnes, killing him. The legal argument: the officer argued that at the exact moment he fired, his life was in danger. He argued the court shouldn't look at his bad decision to jump on the car, only the fact that he was in danger once he was there. Chronological blinders. Justice Kagan wrote that courts cannot put on chronological blinders. They must look at the totality of the circumstances.
A 9-0 decision. Before this ruling, an officer could theoretically violate their training by stepping in front of a car, creating a crisis, and then legally shoot their way out of that crisis as they were currently in danger. Now, ladies and gentlemen, does this theoretical scenario sound familiar to you? The officer in the Felix case made one mistake: stepping onto a vehicle and putting himself in danger. How many mistakes did this agent make? In my opinion, this agent put himself in self-jeopardy by standing in front of the vehicle. Then he stood his ground and started shooting instead of stepping aside when the car began to flee. Then began shooting inside the car at point-blank range when the vehicle was already clear of the agent. Training ignored. Reckless cowboy. Again, just observations based on the evidence we have, and this is the only evidence we have, which is why I want you to do me a favor. When the defense gets up here, ask them this. You're showing us this video. How about showing us some hospital records? We want to see if the agent was in fact injured. You keep saying he followed his training. Show us the training he's following. What training says get in front of a vehicle driven by a mother of three and draw your weapon? What training says stand ground and fire while in front of a moving vehicle? What training says shoot inside a vehicle that is fleeing and presents no danger? Show us. Show us evidence that Renee Good was a domestic terrorist. Where is the evidence? Where is the evidence? And with that, the prosecution rests. Thank you, ladies and gentlemen.